All right. It is August 11th, 2021. We are well into, what is this? Month 17 of the 15 days to flatten the curve. And, well, here we are. None of the safetyism has worked and nobody cares. And so we're going into another school season in Connecticut where people just want to abuse children for federal money. And so at some point, we have realized enough's enough. We gotta do something about it. So this is Unmasking Children, the practical crash course action guide for parents. Now, disclaimer, do take this very seriously. This presentation does not constitute legal advice in any way. It's not legal advice. Nothing herein or similarly remotely similar in the future concerning this material should be construed as the appearance, holding the author or presenter out as acting as an attorney, solicitor, or representative for yourself or any other person before any court, referee, master, auditor, division, department, commission, board, judicial person, or body authorized or constituted by law to determine any question of law or fact or to exercise any judicial power or the preparation of pleadings or other legal papers incident to any action or other proceeding of any kind before or to be brought before a court or other body. 2, the giving or tendering to another person for a consideration, direct or indirect, of any advice or counsel pertaining to a law question or a court action or a judicial proceeding brought or to be brought. 3, the undertaking or acting as a representative or on your behalf or on the behalf of another person to commence, settle, compromise, adjust, or dispose of any civil action or criminal case or cause of action. 4, the preparation or drafting of a will, codicil, corporation, organization, amendment, or qualification papers, civil or criminal complaints, interrogatories, requests for discovery, motions, letters, contracts, offers to settle, notices of tort, or any instrument which requires legal knowledge and capacity is usually prepared by attorneys at law on your behalf. Or 5, communications to, with, or from you remotely dealing with anything resembling law, being the actual practice of law, the offer to do the same, or the act of doing the same in any jurisdiction. You 100% agree to all of the foregoing in viewing this material and especially asking questions later on. So that's where we're coming from. Now, this is for educational purposes only. It is to start you on the process of getting up to speed. It is impossible to hire nearly enough attorneys to get change to happen. This is why this presentation is here. And by the way, before you say, I'm going to vote harder next time, waiting for an election has never, ever worked. Ever. That's why we're here. That's why this is all happening. And of course, anything worth doing is necessarily difficult. So who is this presentation for? This is for parents with kids in a school system in Connecticut. And this is for people who believe and are ready to act to, number 1, expose the safety theater and for what it is, along with the real motivation, which is dollars, and 2, take action to make this even more difficult to do, because that's what it's going to take. They're not going to stop. They cannot be reasoned with. Now, masking in safety theater will not stop on its own. There has never been a real discussion or any sort of shared experience. We've been through that. We're 17 months into it. They've decided when they're going to do this, no matter what, and they've decided how they're going to do this. You need an or else. This presentation is about giving them an or else. You are wasting your time attempting to dissuade school districts, the state, and Democrats and Republicans from safety theater. It pays them too well. They have no plans whatsoever of honoring any medical exemptions, even if signed by multiple board-certified physicians. Not even a note from Dr. Fauci is going to help you. And again, no one is going to do any of this for you. You have to do it for you. You have to do it for your kids. You're on deck. If you want to know where the reinforcements are, take a look in the mirror. Now, why do we fight? We're 17 months into 15 days to flatten the curve. Elections, again, do not end these things, nor have they ever stopped them. You now have problems you can't vote your way out of. Specifically, 1 year of missing education for your children or having their educational and health and psychological outcomes impaired. You can't exactly vote someone in office to fix that, can you? Neither you or your kids will ever be left alone without your action. This is why I'm taking the time to do this, to share my knowledge, such that you can start helping yourself, because There's only one of me. You couldn't possibly get the ACLU on the phone nearly enough to help everybody, and this is where it's at. So it's easier to act now than it is to wait. Again, no one is going to do this for you. So here's what this presentation covers. We talk about FOIA requests, we talk about the complaint process, and what to do when your FOI is not complied with or denied. We talk about the Americans with Disabilities Act. We talk about HIPAA within the context of all of this nonsense. We talk about talking to COVID enforcers, and we talk about attending board meetings. So we also talk about civil actions, ADA, 42 U.S.C. 1983, Qui Tam, and Bill of Discovery. And yes, the very basic anatomy of a complaint, what it is and what it isn't. So we're going to try to get some of these law and order notions and presumptions about the whole legal process out of your head, such that it's not so scary and you start to begin to understand it. We talk about civil case flow and scheduling orders, and that's basically how the trains leave the station, in what order, in key events and cases, and how that happens. And we talk about discovery tools in this presentation. Now, starting with the FOI request. What is an FOI request? This is per the Freedom of Information Act. It is to get records that exist. It does not require the creation of records or of a summary of records. You can get copies, or you can request to inspect records in person. Now, tips for FOIA. Address your letter to the keeper of the records or FOIA officer in the appropriate government agency or department. Do give a range of dates and document subject matters. And of course, specificity and brevity is your friend. And do keep all communication in writing as much as possible. Please ask that they give you the time and cost to task your request. Be polite and do be available to offer help to help them refine your request, and be available to help them task your request. Being nice goes a long way, and especially right now, it goes a very long way. So here is an example of an FOI request. If you're watching this live, you can watch this video later, you can pause it. You can see how it's done. It's pretty simple. This is just documents, subject matters, dates. It's straightforward. It couldn't get any more simple than that. So here is what we're looking for in terms of our subject matter. We're looking for reopening plans. We're looking at discussions of how they were trying to get federal state dollars to implement those plans. We're looking for decisions that have been made by boards of ed outside the confines of an official meeting. We are looking for directives from the state to boards of ed, superintendents in towns and whatnot. And we are looking for plans and strategies to deny ADA and other accommodations and exceptions to the requirements to wear masks and whatnot. Here's a little more of what we're looking for. We are looking for grant applications for COVID-19 related funding. We are looking for contracts for COVID-19 compliance. We are looking for deviations from normal bidding and procurement policies. And we are looking for procedures to comply with HIPAA, ADA, and Individuals with Disabilities Education Act, that's IDEA, relative to COVID-19 reopening plans. And why we're looking for these things is going to become apparent a little later on. So why is this information valuable? COVID-19 compliance, including the masking, is a minefield within HIPAA, ADA, and IDEA. So actions taken outside the regularly noticed meetings can be voided through the FOIA complaint process. So whatever it is they want to do in the safetyism nonsense, we want to undo it and reverse it. That's the whole point of this exercise. And of course, this research, this fact-finding, supports a lawsuit should you have the need to bring one. And if you're really, really greedy, as I'm increasingly becoming myself, Federal False Claims Act suits will claw those federal dollars right back. So it's going to be a field day, and it's the field day we need to have, unless we want to wear masks and be distanced forever. Now, do attend your Board of Ed meetings. They have to know you're there. It's a lot harder to do safety theater if they know you're there. And do speak during public comment, but keep it brief and keep it precise. For example, talking points. I don't believe in harming kids or impairing their educational outcomes for federal dollars. It's wrong. Of course, even if there's only one or two of you per meeting, that's powerful. There will eventually be more of you. Keep it up. And if they attempt to have you removed from the meeting for not wearing a mask, FOI complaint, lawsuit, early and often. We can't put up with this anymore, guys. And if we do, it's not going to stop. So the FOI complaint. you have to specifically allege how your FOI request was not complied with or responded to within 10 days. Do always keep a signed copy of your request and any correspondence that went with it. And if it involves an open meeting and an action taken without an open meeting, be specific. Now, this is a complaint. It's just a sample for, they just never got back to me. I didn't get my records. So, simply put, to the FOIA Commission, please regard this as an FOIA complaint. Specifically, I requested records from blah, blah, blah on such and such date. The request, copy Exhibit A. I have, to date, neither acknowledgement or responsive records. Now, FOI open meeting complaints are a different animal. You are basically going to be filing these when a board or an agency takes official action outside of a meeting. Now, be specific as to the agency or the entity and the action it took outside the scope of an official noticed published meeting. Do indicate why it is illegal and what the action taken was. And file it within 30 days you become aware of it. I try to do 1 or 2 days because they're not making us rest, nor can we make them rest. So here's a sample open meeting complaint. You can pause this, but this describes an unlawful town meeting, and what you can do is you can see, here's the legal reasons why it wasn't legal, here's how it didn't comport with the law, here's how the notice wasn't proper, here's the charter provisions of the town that apply, here's the executive orders that apply, here's the general statutes that apply. So string this together like a logically ordered series of pearls on that necklace such that the FOIA Commission can follow you. Now, talking to COVID cops and education COVID enforcers. Please do it in writing every time possible. That is critical, that's key. Because everything you say in person or over the phone can always be misremembered, misrecollected, misconstrued, and misconstructed later on. And you do know they're going to do that. Persuasion will never work. 99% of the time, maybe 99.5% of the time, it'll never work. Their mission is to deny any and all possible ADA, IDEA exemptions. Your mission is to acquire information, not argue and not debate. The question is always whether they comply with the law or you see them in court. It is that simple. They have taken 17 months of a position and they're not budging. We need to not budge either because this has come down to a contest of wills. It is not a contest of them trying to do the right thing anymore. It is a contest of how many federal dollars can we grab in the name of safetyism. So don't be afraid to state what it is they're doing. They're denying accommodations. The burden of proof is on them. Don't let them forget that. And if they're going to insist on forgetting it, there's a certain point where you're just wasting your time. So when you talk to the COVID enforcers, they never really have a desire to have a dialogue. That's generally true the vast majority of the time. No doctor's note will ever be sufficient. Any threat to their federal funding will be dealt with accordingly, even if it means, and especially if it means, violating your rights to get federal dollars. That's where we're at. So you and your child's situation and your rights need to present more liability than any federal funding is possibly worth. So the COVID enforcer is more afraid of the governor and you losing federal money than you. So speak from a position of the facts. So that includes, of course, fact-finding. Questions for COVID enforcers and FOI Fodder include: do you have a HIPAA training program since you are asking for medical records? Can I inspect my child's medical records up to 6 years from now? How are you storing and handling my child's medical records? And who are you sharing my child's medical records with? Do you have a HIPAA-compliant disclosure release before you ask for those records? These are all key critical questions. So even more questions if you want them. And especially if they seem fit on denying exemptions, you could say, or write especially, you seem dead set on denying my child an accommodation. Isn't it true you asked for my child's medical records under false pretense, that being the case? Of course, you can also ask, I'd rather you just honor the accommodation of not wearing a mask instead of, as a matter of policy, violating HIPAA. Tell me whether you will honor the exemption or you plan on denying the exemption so we can just get to the point and get a lawsuit started. That's where we're at. Don't be afraid to put town council on notice. That's what he or she is paid for, usually at over $100 an hour. So it seems they should have been thinking about this, and if they haven't, you need to go make them. So when you talk to these guys, especially if you write to them, be matter of fact, keep it simple and in chronological order. Apprise them of the claims you plan to bring if your child's exemption is not going to be honored and they purposefully plan on not honoring it as a matter of policy. Remember, this is not a debate. You don't have to be right now. What's important is the cleanup they have to do many, many months from now. They get to select a jury in that future when this is all over. So in other words, they may not be kind to present COVID enforcer, but they figured that's a problem for future COVID enforcer. So if we agree on being cruel to future COVID enforcer, I suppose we should have at it. The town council should know, shouldn't he? So sometimes push comes to shove. Remember, they count on having to fight you in court. So any complaint, as long as it is reasonably based on a sincere belief in probable cause, is better than no complaint if you can't get your matter resolved and you can't get a lawyer for you, or you can't get the ACLU on the phone, or you just can't get anybody to do it for you because we all happen to be very busy with these guys and many hands make for light work. So whether you have a lawyer and resources or not, whether the ACLU picks up your call or not, it is ultimately up to you to enforce your rights. Now, the problem is, we've been doing kind of a terrible job of that, haven't we? And that's why we're here, isn't it? So, you come to the right place, and I guess it's going to take a long time to clean it up, but we're going to get to that. So, when you start to have to deal with attorneys for the other side, they're people just like you. Be kind, be nice, you know, they have feelings. They're people too. Respect them. You, subject to mask and other mandates, are not persuading anybody on fear, threats, or intimidation. So, those sorts of tactics don't work. And if you make a bluff, they're going to call it. But just the same, don't be surprised if they attempt to make a bluff on you. And you got to call it because that's where we are. And everybody's going to call it at every single time. So make an assumption that threats, insults, fear, degradation to counsel, assume these are poorly advised. Obviously, you're going to run into people that are just bad eggs. Attorneys are like any other group of people. There's good ones, there's bad ones, there's nice ones, there's cruel ones, whatever. But just assume, don't start off on that foot. But they speak and advocate for their clients. That's their job. So building rapport is critical for many reasons, including resolving discovery disputes and settlement negotiations, all that other fun stuff. So you're not out after them personally. It's their client. You got to separate the two. So what is a summons and complaint? A summons is a document that formally provides notice of a suit. So if you're a pro se that is self-represented, you'll need a clerk of the court to sign it so it and the complaint can be served. A complaint is a statement of facts that, if proven, support a legal theory of recovery. It is not the means by which you will prove your facts or of any proof. It's not even an argument. And a lot happens other than just service of it and the summons. So remember, this isn't law and order. Civil action is slow, time-consuming, and burdensome to all parties involved. So don't think you file your lawsuit Monday, you're protected right now, or you think you're going to have a trial on Friday. The fact is there's a lot of things that go on. There are temporary injunctions. There's prejudgment remedies. There's different hearings to appoint different officers or special masters, or depending on what sort of procedure you're in. Sometimes, if you're getting really ambitious, you can go for class certification. That's a completely different thing in and of itself. So there's lots of different procedures that come into play depending on your cause of action. And of course, there's discovery, there's depositions, there's scheduling orders, there's a trial, and we'll get to that. So what happens in a lawsuit? There's the pleading stage, the complaint, request to revise, motion to strike, answer to special defenses, and reply to special defenses. This is, of course, a Connecticut-specific presentation. Go read Practice Book 10-8. Federal cases, should you file here in Superior Court first or your state case is removed, a Rule 26F conference is held. The parties jointly prepare a report and the judge approves it, most of the time within reason, as to what the parties agreed to. This basically sets, a scheduling order, like deadlines for pleading, amendments, discovery, dispositive motions, and all sorts of other fun stuff, including experts if you have something that's like, medical or requires some sort of an expert. So an example complaint is, of course, oversimplified. And if you are listening to the live version, you can go back and you can pause this. But here's what it is. This is a hypothetical complaint. The plaintiff got beaten up for not wearing a mask. And that is the set of basic facts. And that violated the plaintiff's rights to be free from arbitrary physical assault under color of law in violation of 42 U.S.C. 1983. So this is formatted for state court, and what it is you have your standard caption. Of course, before you have a docket number, that's where the return date is. The top person is Joe Lunchbucket. He is the plaintiff, versus Municipal Rogue Goon, who is the defendant. You obviously have the date of the pleading. You mention what court it is, what judicial district it in, what court in the judicial district it is in. The top heading is complaint, and that is, of course, what the pleading is. If it was a motion to dismiss, it would say motion to dismiss. If it was request to revise, it would say request to revise. If it was a motion to strike, it would say motion to strike. Or if it was a motion for summary judgment, it would say motion for summary judgment. So that's pretty self-explanatory. The complaint, paragraphs 1 through 4, sets forth, here's what Rogue Municipal Goon defendant did. And then below that, it sets forth, here's the relief I'm asking the court to grant based on the fact that, after I prove that, this is what I want. And so below that, it's the plaintiff, Joe Lunchbucket. Joe Lunchbucket, his address, city, state, phone number, and email. That's self-explanatory. And of course, the document to the right, it is a statement of amount and demand. This goes with every Superior Court action, generally in Connecticut, with some exceptions. It basically just tells you whether the relief is less than $2,500, between $2,500 and $15,000, or greater than $15,000. That doesn't limit the amount of damages. All it does is it tells the clerk, here's the amount in dispute, so the clerk knows what fee to charge you when you file it. Now, what can defendant Rogue Municipal Goon do? Now that you've called him to task, if there is a federal cause of action pleaded, Rogue Municipal Goon can remove it to federal court, or he can leave it in state court. Responsive pleadings include, in this respective order, by the way, if Rogue Municipal Goon jumps ahead and files something, after a order of pleading and the way this is set out, then Rogue Municipal Goon typically waives the right to file it. So the order is motion to dismiss. That's if the return of service isn't good, if the service is bad, or, you just, whatever, relating to service. Or for subject matter jurisdiction, which is the lack of the authority of the court to hear the complaint, he could file a request to revise, which basically would ask for, can you clarify, this part of the complaint? Can you give me more information? Hey, I noticed you numbered this paragraph wrong. Can you go fix it? Or he can file a motion to strike. This is for non-joinder or misjoinder of parties, or for lack of legal sufficiency. Or Rogue Municipal Goon can go right to the answer in special defenses. Now, what do you do? If removed to the federal court, you can reach out and ask if they have a draft Rule 26F report. Both sides mark up a version and one gets filed with the court. Then discovery can commence after the report is approved. The exception generally is if the defendant moves to dismiss the complaint or he moves for a stay of the complaint. Of course, if a request to revise is filed, you can object. Consult the practice book. This isn't legal advice. You need to go out, you need to read these things so you can actually get up to speed. If a motion to strike is filed, you can object. Consult the practice book. Provide authorities on why your complaint is legally sufficient. By the way, the Connecticut Judicial Branch Law Library, those resources are available online and remotely, and law librarians are super nice and helpful. So, of course, they can't give you legal advice either, just like I'm not, but what they can do is point you in the right direction of which resources you might want to look at. So, the other thing Rogue Municipal Goon can do is if an answer is filed with special defenses, if he goes there, you have the option of simply replying to them or even filing your own request to revise or a motion to strike. You might have a question. You might look and he might have a special defense that says, hey, I acted in good faith. And then you can do a request to revise that says, well, what do you mean you acted in good faith? How did you get there? What is it that you're going to prove that proves you acted in good faith? Like, you're just telling me you acted in good faith in one sentence, but I have no factual basis to go ahead and evaluate that, do I? So that's why you would file a request to revise that special defense. Tip, again, pleadings must be filed in Connecticut in a specific order set forth in Practice Book 10-8, or the right to file them is waived. By the way, that's also Practice Book 10-7, and 10-8 actually calls for the time steps in pleadings. With certain exceptions, the vast majority of civil actions have 30-day steps for pleading. So in other words, the return date starts the clock, and After the return date, the defendant has 30 days to file some pleading, or they can ask for a motion for extension of time. Don't get frustrated if they ask for that first motion for extension of time. This is another day at the office for them. I'm sure they're screwing up elsewhere, and they have other plaintiffs just like you to deal with, which they so aptly and richly deserve. So bear in mind, it's just another day in the office. Don't think there's anything special because they're asking for it. So, discovery tools. Again, I did mention before, you got this complaint. Great. Now you got to go out and prove it. Prove everything you're saying in it. So that's why we have discovery. So the first discovery tool we're going to talk about, pretty self-explanatory, requests for admissions. These are used to eliminate matters you need to explore. Example 1, admit or deny. Defendant is a government actor. They're either going to admit it, they're going to deny it, or they're going to object. And if they object, don't be surprised. You know, it's another day at the office, so don't be surprised if you get a whole bunch of objections, because obviously the goal of discovery is to keep the evidence you want to admit out and to try to prevent you from getting evidence that is favorable to you. So that's what the other side is thinking. And requests for admissions can kind of eliminate those matters you'd need to explore so you can get on with the rest of discovery. Think of this like a filtering and sorting process. Because if you all agree defendant is a government actor, you don't even need to go there. You can, if you're in federal court, you can just say in your 26F report, there's a section, facts that the parties agree on. Well, you can list that there. The defendant's a government actor. So you don't even need to ask for it, you know, because you can establish it that way. Interrogatories. These are open-ended questions reduced to writing. Example, what policies did you follow at the time you decided to deny the plaintiff's mask-wearing exemption? And of course, they can answer, they can object, but the whole point is you have something that's written down, so when you come to the depot, you can actually go ahead and you can ask the deponent about their answers to the interrogatories that you served. So usually what you're going to find is a lot of the answers they'll give at a depot there. You learn far more because it's a lot more free form, it's a lot more informal than interrogatories, and you get to gauge their facial expressions and whatnot, but we will get to depositions in a second. So requests for production. This is simply used for obtaining and inspecting objects and tangible things. Examples. Number 1, provide a copy of all policies you followed when you arrested the plaintiff. That's pretty straightforward. It's a document. It's a thing. You want it. 2, please make available for inspection and forensic examination the police cruiser you tossed the plaintiff into. Pretty easy. Pretty self-explanatory. And again, they could object to that. They could try to go for a protective order, whatever. But, you know, the thing is you have to have a discovery conference to resolve it. We'll get to that in a second. So, depositions. These are used to ascertain information too complex for an interrogatory and to get the witnesses and parties' perceptions, senses, and recollections, and to lead to the discovery of admissible or relevant evidence. So the way to do this is you have to create what's called a notice of deposition. You can ask for the production of tangible items. You can do a corporate representative or organizational representative deposition. That's where the corporation or entity must produce a representative to prepare and testify. And if you have a lawyer or you have no lawyer, you can apply for a subpoena for the deposition. So here is a oversimplified example notice of deposition. Example notice of deposition, date, caption, same things. These generally do not get filed by the court. They get filed by the other side in the event that they object or they want to move for a protective order, or for any other reason to support, their argument to the court why you shouldn't be able to take this deposition or do the deposition. So it's pretty straightforward. Plaintiff hereby notices the deposition of Fox Mulder to be taken at date time via Zoom or in person at location X before name of court reporter, to be taken by stenographer and or videographer, and to be sworn in by a notary or other proper officer. Fox Mulder is also requested to produce and bring with him 1, the video footage of space aliens he took on X date. That's pretty straightforward. And below, you'll have your name as the plaintiff, your city, state address, and you have to have a certificate of service where you actually list where you sent a copy of this notice of deposition to. If rogue municipal Goon accepts service by email, do that. Don't play games with the post office. State court does not work on the mailbox rule. Only federal court does. So it's better to just send it by email if you can and they agree to it, because that way you have a record that they actually got it. Otherwise, if it's by snail mail, well, then there it is. Just describe where you sent it and indicate the date on which you sent it. So, discovery disputes. They're going to happen. They always do. This is just another day at the office. The other side almost always objects. This is normal. Please don't sweat it. It's not to be mean. It's to kind of try to eliminate the burden. It's just, most of the time, it's in good faith. They're trying to protect attorney-client privilege, in which case they need a privilege log. Sometimes they're like, your request calls for 8 bazillion documents. Is there any way you could narrow this down? That's why the rules, state and federal, provide that the parties have to attempt a conference in good faith to resolve those differences. And be nice, be courteous, and be kind. Don't assume ill intentions or bad motives. As to the other side, there's probably something you might have missed. Be open to it. You can learn a lot by listening. Otherwise, you should be able to explain why your request is relevant and necessary and will lead to admissible evidence. Don't be afraid to explain it. Of course, you know your case better than anybody else. You're the plaintiff. So you want to do that. And if you can't get everything resolved, then you both should jointly request a status conference with a judge. The state superior court has forms for that. They have procedures for that. So read the standing orders. Federally, they have standing orders for that too. Federally, it is Rule 37 you might want to look at. Again, this isn't legal advice, but that's just where you could find it. Federally, your requests for admissions, production interrogatories, you're going to be dealing with Rule 31, Rule 33, and Rule 34. As far as the state court practice book goes, you're going to want to look at Chapter 13. Chapter 13.2 covers like statements, what's generally discoverable. Chapter 13.5 has to do with protective orders. Chapter 13-6, that is your interrogatories. 13-9 is your request for productions. And of course, 13-7 and 8, those deal with objections to interrogatories. 13-9 deals with objections to requests for production. 13-23 actually deals with requests for admissions, or actually objections. And the admissions themselves are governed by Practice Book 13-22. Key tip, the practice book does say at 13-23 that if they don't admit or deny admission within 30 days and they don't get more time, then generally that admission is deemed admitted. So do pay attention to the deadlines. The deadlines federally, as far as the interrogatories and requests for production, 30 days to respond, whether it's to produce or to object or to ask for more time. In state court, interrogatories, requests for production are 60 days, although admissions are 30. That is, again, unless, there's an objection, they have 30 days or 6 days, whatever the case may be, to object or respond. But again, kindness goes a long way. If you're accommodating, they'll generally be accommodated to you unless they're really evil, but don't presume. I'm sure you're going to find out which one it is. So, causes of action. This is what we're probably going to be fighting for in all likelihood. And again, this is not legal advice. It shouldn't be taken as legal advice. This is just to get you on the path to learn exactly what sort of tools you probably might be able to use depending on your situation. The Americans with Disabilities Act, that's a big one. 42 U.S.C. 1983, Qui Tam, that is the Federal False Claims Act, and Bills of Discovery, which is an action to find out if you have a civil action. Again, not legal advice. This is just an educational primer to start you off on your own work, due diligence, and research. Because the good thing is, although this may seem like a lot, you're basically getting a solid education that otherwise probably would have cost you a few grand to get. So this is a foundation. This is not the end-all, be-all. And you're going to be able to play with this and experiment and figure it out and improvise on your own. And just maybe it could be the most fun you have with your clothes on. So rather than being just depressed, you can turn this around and you can think positively and you can get creative. So the Americans with Disabilities Act, who is protected? One, a disability is a physical or mental impairment that substantially limits one or more major life activities, and it consists of a record of such impairment, and it consists of being regarded as having such an impairment as described later on in the statutes. So major life activities, these include manual tasks like seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. Major bodily functions for the purposes of this include major life activities, such as a major bodily function functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. So this is pretty self-explanatory. Obviously, if you're blind, you're protected under the ADA. Obviously, if you can't breathe because you got asthma, you're protected under the ADA. Obviously, if you're dyslexic, that's protected under the ADA because it's cognitive. So what is the general rule? No individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, and advantages or accommodations of any place of public accommodation by any person who owns, leases, or leases to, or operates a place of public accommodation. Schools, gyms, you get the idea. So here's 3 things that can happen that are critical for our exercise. Denial of participation, and participation on equal benefit, separate benefit, and individual or class of individuals. So also from that statute, things that people should not do unless they want to get sued under the ADA is an individual or entity shall not directly or through contract or other means utilize standards or criteria or methods of administration that have the effect of discriminating on the basis of disability, or that perpetuate the discrimination of others who are subject to a common administrative control. Remember I said earlier, they wouldn't even care if you had a note from Dr. Fauci. So you get your thing, you go on with that, and they say, this isn't good enough. We want more from this doctor. Well, there you go. They've already discriminated against you. Or they ask you when you come in, you need to provide medical records. Well, piss off. You've just discriminated against me. So association, it shall be discriminatory to exclude or otherwise deny equal goods, services, facilities, privileges, advantage, accommodations, or other opportunities to an individual or entity because that known disability of an individual with whom the individual or entity is known to have a relationship or of association. When they start to use words like, you must be one of those anti-maskers, well, guess what? You just did that. You shouldn't have done that. Now I have another count to my complaint, don't I? So also from the statutes, specific prohibitions. For the purposes of subsection A, discrimination includes the imposition or application of eligibility criteria that screen out or tend to screen out an individual with a disability or any class of individuals with disabilities from fully and equally enjoying any goods, services, facilities, privileges, advantages, or accommodations unless such criteria can be shown to be necessary for the provision of such goods, services, facilities, privileges, advantages, or accommodations being offered. So, practical example, 1 or 2 examples. Example 1, what they do right now, where they say everybody's got to wear a mask, no matter what. Well, guess what? You've just screened people. Example number 2, when you did it right. Say somebody goes, I'm immune compromised, I'm worried about COVID. Here, have an N95 mask. That's reasonable. That would actually protect you. That wouldn't be safety theater. That would protect them. That would protect anybody they live with that has, some sort of disability. That's not unreasonable. If somebody went into a school and said, I'm worried about COVID, I have X condition, and if I get COVID, it's going to be really bad, put on an N95. Otherwise, it goes against everybody else. So you can't require the whole facility to kowtow to your demand at a certain point, because at a certain point, kids need to see facial expressions. They need to be able to communicate. They have their own IDEA programs. So this is the thing. We're basically dealing with a situation where ADA has been turned on its head. So special defense, we hope Defendant Municipal Goon is dumb enough to plead and attempt to prove. Nothing in the subchapter shall require an entity to permit an individual to participate in or benefit from the goods, services, facilities, privileges, advantages, and accommodations of such entity where such individual poses a direct threat to the health or safety of others. The term direct threat means a significant risk to the health or safety of others that cannot be eliminated by modification of policies, practices, or procedures, or by the provision of auxiliary aids or services. Read, prove how anyone specifically is spreading COVID. We will wait. Show us your notes. We're happy to cross-examine your expert at trial. We're happy to depose your expert. I want your expert's report. I want to know, when did your expert PCR test the plaintiff? That's going to be fun, and I'm looking forward to it. So your move, Municipal Goon, I'm sure that'll come up. And when it does, let's just sit back and eat popcorn. So 42 U.S.C. 1983. It states, every person who, under color of any statute, ordinance, custom, usage of any state or territory to the District of Columbia, subjects or causes to be subject, any citizen of the United States or any other person within the jurisdiction thereof, to the deprivation of any rights, privileges, or immunities secured by the constitutional laws, shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. So, Without the rest of it, you can pause this if you're watching this later. That's self-explanatory. So what are your critical elements? And again, this is very simplified, and this doesn't talk about Bivens actions. It doesn't talk about Monell claims. It doesn't talk about specific violations of a specific constitutional right. But the elements core, before you get into all those other layers, depending on what it is, are a government actor, 1, denied you a right secured under the law or the Constitution, 2, did it under color of law or authority of law or of custom of usage, and 3, it resulted in infringement of your rights with or without damage. So basically, if your rights have been infringed, you're inherently damaged. That's called nominal damages. You can win $1. As to the second element, did it under color of law or authority of law or customer usage? Sometimes a lot of districts, departments, towns, agencies, they have unwritten things that they always do, which is a customer usage is what it's called. It's like, okay, we always put the paper clips over there. We didn't necessarily need a policy to do it, but we just did it to keep it away from the people who are not wearing masks. Like, obviously, no one's going to have something like that, but that would just give you an example of what a customer usage would be. So, 1983 hypothetical examples. Again, not legal advice, but, you know, it is for educational example purposes. Your child was denied a right under ADA or IDEA, for example, because he was exempted from wearing a mask, but they said, no, we're going to make you wear a mask anyway. Or defendant, municipal town enforcer, forced the requirement to wear a mask anyway, or denied your child education at all, or instead. And key, you must show the existence of a legal right protected by the law or the U.S. Constitution. It may even be, just possibly, I'm spitballing here, within the exemption set forth in the relevant executive orders themselves. It's not like these, oh wait, they do say that people are exempt. Well, how about that? Federal False Claims Act. This is filed by a plaintiff called the relator who is suing on behalf of the United States government. So, for example, it would be United States ex-rel Joe Lunchbucket versus Municipal Goon enforcer that misappropriated federal money. Best of luck to him. So, what this is you sue on behalf of the federal government to recover misappropriated property or funds that did not reach their intended beneficiaries or otherwise were misused. And you must file these actions under seal, and you must follow those procedures, and you have to afford the U.S. Attorney's Office at least 4 months to evaluate your claim and proofs of claim. Though you can't just tell the world about it, you can't just file it like a regular complaint, you have to tell the clerk, I'm filing this under seal. So, just from the Department of Justice's website, this was from about a week ago, and you can see this is actually a thing. There's actually a Department of Justice program for this, and yes, they actually did take in $2.2 billion last year. So, it's Qui Tam Hunting season. The primary motivator for safety theater is not an actual fear of COVID. Rather, it is pure, unprecedented, and life-changing sums of federal money. That is the number one thing. And it's not about fear of COVID at all, in the broadest sense. These are grants and contracts that range from testing all the way to public works and school system level contracts that have nothing to do with COVID. They have nothing at all to do with COVID, but the money spigot has opened, and in order to make this stop, we need to claw it back. So we need to make that money move in the opposite direction, and the prospect of it far more likely sufficient to deter those from seeking to fund reckless safetyism. So here are the elements. You're looking for a grant or a contract that was not dispersed per application award. You could be looking for a product and services that did not perform per the contract specs. Like, for example, they put out a COVID test that was supposed to be like 99% accurate, and then you find out it's only 30, and you go through the process to scientifically prove that, and then you bring that to the U.S. Attorney's Office and say, look, I think the testing manufacturer porked you. Let's go after them. And of course, you're also looking for beneficiaries of aid and accommodations that denied said benefits or aid that never reached the intended beneficiaries. I mean, just take a look at the whole rental assistance program. Reunite Connecticut couldn't be a bigger joke. I mean, they got $247 million, and they've not even handed out, I believe, as of this presentation, less than 30. And they've had it since March. So we're dealing with problems that are just institutionally impossible for the COVID screamers to keep up with. And we need to exploit those, and hopefully you need to get paid. So do your due diligence. Document your investigation of the source of federal funds and who they were go to and how they did not get there. Do it quietly. Don't tell anyone, except your lawyer if you have one, about the specifics of the case you're developing. And of course, Qui Tam actions, again, they must be kept confidential until they are unsealed. So, Q&A. I know I'm just going to go through a few things because this is, it's live, but it's not interactive, and I know if somebody's commenting, I can't see you right now because I'm in full screen. One question I frequently get is, I'm really afraid. What do I do? This is a lot to take on. And I say, look, you got some catch-up work to do. It's not the end of the world. They can't throw you in jail for doing this. They can't do anything worse than they intended to do to you anyway. So this is not the time to be afraid. This is the time to take action. So otherwise, I would just kind of suggest reach out to me, headlinecopy@gmail.com. Facebook Messenger is a terrible way to get a hold of me. And of course, do share this. At some point, I would like to do something a little more comprehensive, but considering the school year is kind of